Okay, let's dive right into this explainer. Welcome, everyone. Today, we're unpacking a really fascinating, incredibly high-stakes legal clash that actually made its way all the way to the Philippine Supreme Court. We are looking at the case of Santiago Sillano versus JGC Philippines, Inc. Now, you might be thinking this is just some dry legal dispute, but it's really not. It's a massive corporate battle over a question that, honestly, affects pretty much every modern worker out there. Think about it. Who actually owns the true fruits of your labor when you create something absolutely incredible on company time?
So here is our roadmap for untangling today's legal mystery. We're going to hit 1. The Great Software Lockout. 2. Employee versus employer. 3. The Supreme Court ruling. 4. The dissenting view. And finally 5. Key takeaways for you. Let's see exactly where labor law collides with intellectual property.
I want you to just imagine this scenario for a second. You're at your job, right? And over the course of several years, you use your own highly specialized skills to build this incredibly valuable software that makes all of your company's projects run flawlessly. You built the whole thing. You know exactly how it works. Then, out of nowhere, your boss marches in and orders you to surrender the source code and hand over all the keys. Do you have to say yes? Or is that code yours to protect? Just keep that in the back of your mind as we get into the facts. Okay, Section 1, the Great Software Lockout, or when code literally becomes a battleground. So our story kicks off with Santiago Sillano. He worked his way up from a junior to a senior engineer at JGC Philippines over the span of a decade. But during that time, he wasn't just sitting there doing routine tasks, he was actively innovating. He built 5 really complex, highly valuable computer programs. These were serious engineering tools used specifically for JGC's design and construction management. We're talking about the Connection Input Instant, the XSteel to STAD Converter version 1, the Winload Generator version 2, the Rebar Extractor, and the Compression Check, the whole shebang. And by January 2004, these 5 exact creations became the absolute epicenter of a massive corporate showdown.
In this ownership dispute, it's spread like wildfire. The timeline is wild. In early January 2004, Sillano says, "Hey, I own these programs," while JGC says, "No, we own them." So what does Sillano do? He actually activates the security features on the software. He locks his own company out. He literally made the programs inaccessible for JGC's business projects. Well, JGC strikes back fast. On January 14, they hit him with a notice to explain and slap him right on preventative suspension. Now, Sillano does offer to adjust the time lock mechanism as a sort of compromise, but he flat out refuses to take the security features off entirely. By January 22, JGC issues a final, formal demand to unlock the features and hand over the source codes. Sillano stands his ground. And finally, on February 16th, JGC just terminates him for willful disobedience.
Moving on to Section 2, Employee versus employer. The dueling claims. This brings us to the core legal conflict, and it's like a giant tug-of-war where both sides felt 100% justified and even rushed to the National Library to try and secure the copyrights. Sillano's stance was pretty straightforward. He argued that absolutely nothing in his employment contract, not when he was a junior engineer, not when he was a senior engineer, said that developing software was part of his job description. Crucially, there was zero clause automatically transferring ownership of his creations over to JGC. So in his mind, he retains the copyright, meaning he has every right to lock the software. On the flip side, JGC argued, look, these programs were created on company time, using our company resources specifically for our engineering projects. To them, any work product from an employee automatically belongs to the employer, meaning Sillano's lockout to JGC, that was pure insubordination.
Section 3. The Supreme Court ruling. The nuance verdict.
Okay, so this entire mess had to be untangled by the Supreme Court of the Philippines. And to really get their beautifully layered ruling, we first have to talk about preventive suspension. It's absolutely crucial to note that this is a disciplinary measure, okay? It is not a penalty. It's simply a protective tool an employer uses to secure life or property while an investigation is happening, and legally, it can't go over 30 days. The labor tribunals, and eventually the Supreme Court, all agreed that JGC's use of this preventive suspension was totally valid. Why? Because at that specific time, we're talking January 2004, the legal ownership of that software was totally up in the air. Sillano locking the software posed a very real imminent threat to what JGC, at least at that moment, deemed to be its property.
So here is how the court split this decision, and it's a really fascinating 3-part consensus. Number 1, the dismissal was illegal. JGC thought they were giving a lawful order to hand over the code, but they completely failed to prove Sillano had any kind of wrongful or perverse attitude. He was just trying to protect what he firmly believed was his copyright, which, by the way, the Intellectual Property Office later confirmed. Since JGC didn't actually own the code, their order to surrender it wasn't a lawful order to begin with. Number 2. The suspension, however, was valid. As we just discussed, the immediate threat to JGC's operations was real, and JGC wrapped up the suspension right on the 30th day, perfectly under the legal limit. Number 3. Damages were denied. Sillano went after actual, moral, and exemplary damages, plus unpaid benefits. But the court shut that down simply because he submitted the evidence for all those claims way too late in the appeals process. As the court bluntly put it, clients are bound by the mistakes of their counsel.
Now, the Supreme Court did toss in one final modification to the lower court's rulings. They tacked on a 6% per annum legal interest on the separation pay and back wages awarded to Sillano, which calculates from the finality of the decision all the way until full payment. To put that into perspective, it's a standard legal measure for sure, but that is a highly significant financial addition to an illegal dismissal award.
Which brings us to Section 4, the dissenting view. When copyright vests, the Supreme Court's ruling wasn't actually unanimous. There was a really powerful dissenting opinion from Justice Tamampapo, and it completely flips the logic of that preventative suspension on its head. He points directly to Section 172 of the Intellectual Property Code. He argued that copyright vests upon the sole fact of creation. It doesn't sit around waiting for some government office to make a ruling. Because Sillano owned that code the exact second he wrote it, JJC never held the title. And if JJC never owned it, Sillano's lockout couldn't possibly be a threat to JJC's property. In the dissent's eyes, Sillano shouldn't have been suspended in the first place. He was literally just enforcing his own legal intellectual property rights against an employer trying to take them.
Finally, Section 5. Key takeaways for you. Protecting your creations. All right, we've dug through all this dense legal jurisprudence. But what is the actual so what here for you? Whether you're an employee building incredible tools or a manager trying to keep operations smooth, follow these steps to avoid a literal decade-long legal nightmare. Step 1. Review your employment contract right now. Does it explicitly say who owns the intellectual property for things created on the job? Step 2. Establish clear ownership agreements early. Actually, the Supreme Court pointed out that JGC could have avoided this whole mess by just drafting a clear assignment contract with Sillano before he started coding. Step 3. If you ever find yourself in a legal dispute, you absolutely must follow strict procedural rules and timelines. Sillano missed out on massive damage claims just because his evidence was submitted too late. And that leads us right into our final thought for the day. The modern workplace is constantly changing, and that line between an employee's personal genius and a company's property, it is incredibly thin. So I want to leave you with this to chew on. Is your current employment contract actively protecting your creations, or are you unwittingly giving them all away? Thank you so much for joining me for this explainer, and we'll see you next time.